Well, that's just the way the legal system works. Legendary American comedian, formerly very well received and now not so much, Bill Cosby, is now freed and his convictions have been overturned based on some legal technicalities or legal mishandlings that were done during his case by his prosecutors, and the Supreme Court in Pennsylvania decided to throw the case out because of this. And I'm going to be making a link there between that legal proceedings and another set of legal proceedings that took place over here in Trinidad between a Fete promoter and our Environmental Management Authority, where we saw that the Fete promoter actually won and the case turned in their favor because the actions that were taken by the Environmental Management Authority were seen to be outside of the powers given to them under the Constitution and under the law. And it's something similar when you look at what the case was thrown out for in the case of Mr. Bill Cosby. Bill Cosby freed after top court overturned sexual assault conviction. US comedian Bill Cosby has left prison hours after his sexual assault conviction was overturned by Pennsylvania's Supreme Court. The judges said there had been a process violation by the prosecution, but admitted their ruling was unusual. Mr. Cosby, 83, served more than 2 years of a 3-year to 10-year sentence at a state prison near Philadelphia. In 2018, he was found guilty of drugging and molesting ex-basketball player Andrea Constant. So let's get directly down to it. What exactly did the court say? And what was the problem that the court found? That they saw that this problem was too much to allow the conviction to stand. What did the court say? The judge's reasoning is complex. Their written finding is 79 pages long. They cite a written agreement reached by Mr. Castor, the former prosecutor, stating that he would not charge Mr. Cosby if he testified in Ms. Constant's civil lawsuit. In Wednesday's ruling, the Supreme Court judges also found that the testimony from accusers unrelated to the case had tainted the trial. There's only one remedy that can completely restore Cosby to the status quo ante. He must be discharged and any further prosecution on these particular charges must be barred. The finding released on Wednesday reads, "We do not dispute that this remedy is both severe and rare, but it is warranted here." There were two cases. The accuser brought a civil case earlier before the criminal case was brought. And during that case, in order to get Mr. Cosby's testimony, the prosecutor at that time offered him a deal, a promise, that he is not going to charge him if he provides this testimony. The subsequent prosecutor, the prosecutor that came afterward, went back on that deal and proceeded to use that same testimony to press the charges as evidence in the arrest and charging of Mr. Cosby. Something that contravened the deal. And you could understand also, if you know anything about the legal system, whether it be just from a bit of viewing on television and TV shows, you'd know that a lot of the legal system has to do with the prosecutors and prosecution making deals. And if the deals that a prosecutor makes cannot be held as being trustworthy, cannot be held as something that this person knows that if I take this deal from this prosecutor, they would hold up their end of the bargain. If that cannot be found to be true anymore, you're putting all future cases in the entire legal system at a bit of risk. And bear in mind, this is just repeating something that I said yesterday when I spoke in my contemplation about the same case, but it's getting into some more detail. The legal system works on trust. I go to the legal system because I trust that I'd get justice in this system. In the first place, I don't think that the legal system really provides justice. When you think about it, anytime it is that I could pay to get a better lawyer, and if I get a better lawyer, the chance that I get justice increases, then that isn't really justice. If I could pay, and when I pay, my chances of receiving justice increases, then buying justice makes it not justice, doesn't it? And the thought I had in this case, when we're talking about money, because in this case, the reason this was thrown out was because it reached to the Supreme Court. If Mr. Cosby didn't have the resources to carry this to the Supreme Court. Now, I'm not talking about whether he's innocent or guilty. That case passed a while ago. I have no interest in rehashing that. The court already found him guilty, so we'd work on the court finding that he's guilty. But according to the Supreme Court's ruling, by overturning his conviction, they're basically saying that he should have never been found guilty in the first place. So the years he spent in prison, those 2+ years, would technically be wrongful imprisonment. I wonder if he would be eligible in this case to actually receiving some compensation for the time he spent in prison. Because according to what the court says, if the conviction was wrongful and followed incorrect procedure in the first place, thereby contravening Mr. Cosby's rights, then he was wrongfully imprisoned and he may in fact be eligible to some compensation. That may add even a little more sting to it. But I wonder also, if we turn this case around, if it was in the case of someone who didn't have that level of resources, and they were innocent. Imagine this person was innocent and they didn't have that level of resources. And the prosecutors did the same thing, made a deal with them and then went back on the deal and whatever. And then they were convicted and they didn't have the resources. What would have been their portion? They would have had to have sit in that prison until their sentence ran out or their life ran out, whichever one came first. So to me, that shows the whole injustice of the justice system, that money makes the justice system move. And from the moment you have that amount of money needed to make the system move, then injustices would be very regular among people who are not capable of affording the price of figuring out whether what happened to them was really a case of justice or not. And the thing is, the legal officers, when you meet a legal officer, whether they be the prosecutor or whether they be a police officer, you're assuming that what they're doing is within their right, is within their authority given to them under the law. You assume that the actions that a police officer takes or the statements that a prosecutor makes, that they have the authority to do such. And sometimes they don't. And if you don't have the resources to actually launch a case and find out if they don't, then they may be acting against you, against your constitutional rights, in effect working illegally against you, and you may be just taking it because you cannot find out otherwise. And that may just be the case with many events that have been closed and shut down previously by the EMA and the police officers for noise violations. A Fete promoter recently brought a case before our courts where they brought up the EMA and the police as two defendants in a case for shutting down their event that they held in the run-up to the 2019 carnival. And this is a relatively regular occurrence with police officers shutting down various events when they determine that it has contravened some law. But according to the courts in this case, that isn't within their purview of powers. Fete promoter wins court case against EMA. Carnival Events Company Wild Goose Limited has won its case against the Environmental Management Authority after the latter ordered the former to shut down an event it was hosting in 2019. On Friday, High Court Judge Margaret Mohammed ruled that the decision to shut down the Tailgate Carnival event on February 27, 2019, before the scheduled 2 a.m. end time, was illegal, unlawful, and unauthorized. So, I have a copy of the actual ruling, all 69 pages of it, and I actually read through it. It's more interesting than you might think. I'd obviously leave a link to this in the description if you'd like to follow suit and read through, but of course, we aren't going to read through the entirety of this. It's a court ruling, 69 pages of legal vocabulary, of legal language. It wouldn't make necessarily for entertaining reading out loud, but I think if we go through pieces of the actual court ruling itself, we'll be able to see exactly where the police went wrong, where they overstepped their bounds, where the EMA overstepped their bounds, and what exactly it was about this that threw this case out. Because some people are thinking that This now creates an opening for all fetes to just blast music at the loudest volume that they want to, and police officers cannot do anything about it, and now there's no control over the volume at events and how long they might go. And that's obviously not what happened. That's obviously not what the ruling was. The ruling pertained to the procedural elements of it, what the EMA are allowed to do by procedure and by their legal boundings, and what police are able to do by procedure and by their legal boundings also. So in this case, the claimant would be Wild Goose Limited. These are the promoters of the event. The first defendant would be the Environmental Management Authority of Trinidad and Tobago, the EMA, and bear in mind the EMA would have had a group of officers unseen that would have been acting under the EMA authority, and then the second defendant would have been the senior superintendent of police, Garth Nelson. He would have been the senior officer on the scene. He would not have been directly under the EMA purview. He would have been there as a police officer attempting to keep the peace in and around the event. So the general story goes something like this, that on the night in question, the event was going on. Sometime during the night, the officers that were on the scene working with the EMA, they were monitoring the noise levels. At some point in time, they noticed that the noise levels went over the prescribed level that was written on. Bear in mind, the FET promoters, the event hosts, would have had to have gotten a noise variation permit from the EMA before hosting the event, and they would have had that. And at the event, with this noise variation permit, they would be allowed a stipulated volume that they were allowed to reach up to, and then as time got later in the night, that volume would actually decrease. So at various points in time during the night, the promoter was told by the officers on the scene that the volume was increasing, it was over the level that was prescribed, and at one point in time, the promoter was told that he would have to pay a fine if it was continued like that. And eventually, due to different circumstances, there are some conflicts in the story there. The promoter made it clear that, well, at least he made it seem that one of the things that inveigled the police to close down the event was that there was some talk being thrown from the stage about the police attempting to shut down the event, and that the EMA want to shut it down and we're not taking them on, and that kind of talk. And he said the talk was basically skits to attempt to gas up the crowd and tune up the crowd, hype up the crowd. The police found it to be disrespectful, and we know how Trinidad police deals with disrespect already. And at some point in time later on in the night, according to the EMA, the officers under the EMA's control, they said that the volume just reached too loud and they closed it. The suggestion made by the promoter was that the police were basically temperamental a bit in their closure of the event. So all of it comes down basically to one main question. The question is, was the decision by the servants and or agents of the first defendant to turn off the music at the event illegal, ultra-virus, and excess of jurisdiction or beyond their power? It was submitted on behalf of the first defendant that its servants and or agents had the power to make the decision to turn off the music at the event or shut down the event pursuant to A, sections 51, 62, 63, and 68 of the EM Act, EM being the Environmental Management Act, B, section 25C of the EM Act, as it was an exercise of an emergency power, C, the implied powers of the EM Act, and section 49 of the Summary Offensive Act, as there was a breach of the peace by the claimant. Finally, section 70 of the Summary Offensive Act and the common law, as the claimant had caused a public nuisance. So all of these sections and acts would be parts of our constitution, parts of our national constitution in Trinidad and Tobago here, that the authorities are supposed to abide by and that they derive their authority from. So we are going to attempt to at least read through the direct portions of the Constitution that pertain to what they are speaking about here and discuss the rest, hopefully. So the first point they make, sections 51, 62, 63, and 68 of the Environmental Management Act, and we're going to see what those are. Section 51 of the Environmental Management Act provides that no person shall release or cause to be released any air pollutant into the environment which is in violation of any applicable standards, conditions, or permit requirements under this Act. So section 51 deals with air pollution. No one shall pollute the air. Part 2 of section 51 deals with more specifically noise pollution. No person shall emit or cause to be emitted any noise greater in volume or intensity than prescribed in rules made under section 26 or by any applicable standards, conditions, or requirements under this act. So section 51 of the AM Act is what makes noise pollution illegal. Good. Section 63 of the AM Act states that where the authority reasonably believes that a person is in violation of an environmental requirement, the authority shall serve a written notice of a violation on such a person in a form determined by the board. So section 63 of the AM Act pertains to how exactly the environmental authority deals with people who contravene the previous sections. So if someone breaks this noise pollution law, if someone breaks this air pollution law, what do you do to them? And according to this section, you have to serve them first a written notice. And this written notice must have on it very specific things. Next, we have section 68. Section 68 provides whenever the authority reasonably believes that any person is currently in violation of any environmental requirement or is engaged in any activity which is likely to result in a violation of any environmental requirement, the authority may, in addition to or in lieu of other actions authorized under this act, seek a restraining order, seek an order for the closure of the facility, or pursue any other remedy which may be provided by the law. So this particular section is the section that they're aiming at. Because we could read the next line, sections 51 and 63 of the EM Act, when read together, do not assist the first defendant's case. So the first part that just speaks about noise pollution being illegal, the judge says that has nothing to do with the case. The second part, when it deals about the procedure with the written notice, that doesn't help their case either. The part that they intended to use was part C of section 68, that says they could pursue any other remedy which may be provided by the law. And the remedy that what they suggested is the remedy they pursued was shutting down the event. But the judge wasn't having that. In my opinion, the interpretation of section 68C, which the counsel of the claimant has submitted, is very narrow. The other remedy provided by the law in section 68C includes seeking an order for damages before a court of law and also taking steps under the Police Service Act and Summary Offences Act, both of which offer remedies in the criminal jurisdiction. So what the judge said is that the other remedies have already been provided for. You could seek remedies by carrying them to court. You could seek remedies by bringing police officers to deal with them on a criminal matter. So none of those sections allow the EMA to shut down the event. We move on now to section 25. Section 25 deals with the emergency power of the EMA, and that was another argument that they used, that they had emergency power to shut down this event. But this emergency power has a limit, because section 25 of the law says whenever the authority reasonably believes that a release or a threat of a release of a pollutant or hazardous substance or any other environmental condition presents a threat to human health or the environment, the authority may, after consultation with the minister and in coordination with other appropriate government entities, and they go on to provide several things the authority could do after that. But importantly there, and this is what the judge noted, there must be consultation with the minister, which there wasn't any of. So you cannot say that you are trying to use your emergency powers if you do not go through the procedure that you need to go through in order to use these powers. The final argument used by the Environmental Management Authority, the EMA, to try to make their point on why they had the authority to shut down the event was that they had the implied authority, meaning that although the law may not have clearly stated that they had the authority to shut down the event, because there is a law that states they do have the authority to monitor and observe and report on pollution and on levels that are over what may be considered healthy, it should be implied that obviously they wouldn't be given the authority to look over this without being given the authority to actually take action if something is to be done. However, the argument by the claimant, the argument by the promoters, the argument that was agreed to by the judge was that coercive powers, coercive meaning powers that involve force or threats of violence, and coercive powers are not implied in the law. You do not imply that some group in a country has the authority to make you do something by force or threat of violence. That isn't implied. That is something that is clearly stipulated in the law. And they do not have that clearly stipulated authority in the law. So you cannot attempt to imply coercive power. You must see that written in the law, or you are in contravention of the law, and that's what the judge found. There was no implied authority for the EMA in this case. Moving on from there, though, is the authority of the police officers on the scene. If the police officers on the scene had the authority to shut down the event. So in this case, the police officers attempted to build their case for their authority based on several things, starting with the Police Service Act, the section 45, then 46, which gives them the authority, and then attempting to define what they were arresting the people on. So let's read through. Section 45 of the Police Service Act reads, a police officer shall preserve the peace and detect crime and other breaches of the law. So a police officer shall preserve the peace. What can a police officer do in order to preserve the peace? Well, section 46 of the Police Service Act says a police officer may arrest without a warrant a person who commits a breach of peace in his presence. So now we must see what exactly is this breach of peace. So section 49 of the Summary Offences Act defines what exactly a breach of peace is. Any person making use of any insulting, annoying, or violent language with intent to, or which might tend to, provoke any other person to commit a breach of the peace, and any person who uses any obscene, indecent, or profane language to the annoyance of any resident or any person in any street, or of any person in a place which the public is admitted or has access, or who fights or otherwise disturbs the peace, is liable to a fine of $200 or to imprisonment for 30 days. So that's what a breach of the peace is. If you never knew, now you knew. The second part is what is a public nuisance. Section 70 of the Summary Offences Act deals with the crime of public nuisance. Any person who cause a nuisance to the public, and any person who at any time takes any part in causing such a nuisance, and any person occupying or having control over any house, yard, or premises of whatever nature who permits such nuisance in such house, yard, or premises, is without prejudice to be anything contained in any other law liable on summary conviction to a fine of $1,500 or to imprisonment for 6 months. Now, I find legal language to be just so kind of muddy. It seems nearly like they write purposefully trying to make it confusing, but so be it. In the judge's view, these parts of law did not provide the police with the authority to shut down the music. According to the judge, what this law would allow, at best, they would be able to arrest without a warrant, because that's what the Police Service Act gives them the authority to do. The police may arrest without a warrant someone who breaches the peace. You may not turn off the music of someone who breaches the peace. So if you found that they were indeed breaching the peace, what you could have done was arrest them. And seeing as no arrests were made, the argument for breach of the peace is kind of killed on that alone. If there was a breach of the peace, there are supposed to be some arrests made. So in the end, the judge found that there wasn't enough evidence of a breach of peace, and there wasn't enough evidence of a public nuisance either, because public nuisance had to include with it some amount of nuisance to the public. And there were no reports of any reports being made by anyone in or around the region that stated that this was being problematic to them. So how could it have been a public nuisance if the public didn't voice their nuisance of it? So the case for it being a public nuisance wasn't there. The case for it being a breach of peace wasn't there. So the police had no say in the matter. The police had no authority in the matter. The case that the EMA had was also thrown out based on the fact that it was seen that they were a statutory body and they did not have the authority to go and turn off anyone's music. What they did have the authority to do was revoke the license for the noise variance. And if they wanted to revoke that license, there was a procedure to go through. If they did want to act on emergency power, if they said that the volume that was happening at this current time was such that it needed some emergency action, what the judge said was the law provided what you needed to do for that emergency action. Call the minister. You have contact with the minister, and after that, then you proceed along several other steps. There are several other steps. It's not just one call and then do your own thing. So can we please follow procedure? One of the good things in this case is that the country didn't suffer a severe financial loss based on it. I believe the ruling was, in the end, $30,000, and $10,000 of it was just returned money to the plaintiff. So that's a good part. I hope that you weren't bored by the legal language and us going through this. I do enjoy some of these things sometimes. If you see something like this that you find interesting and you like to see if I'd like to go through it, do send it to me. My email should be in the description. Send me the stuff. Let's see what we think. Click that like button if you haven't clicked it yet, and if you're not subscribed, do subscribe, and I'll see you tomorrow for the next video.
And you feel the music, rising with the tide.